And today we are here to talk about the Alec Baldwin case, his upcoming trial on charges of manslaughter in the killing of cinematographer Helena Hutchins on the set of Rust. And his highly paid legal defense team is filing all kinds of motions, some substantive, some just kind of peeing into the wind, but trying whatever they can to benefit their client, as they're supposed to do. Defense counsel, their obligation is to zealously advocate for their client. Unfortunately, based on facts and law, their client is almost certainly guilty of the involuntary manslaughter with which he is charged over the death of Helena Hutchins, because he pointed what he knew to be a real gun directly at Helena Hutchins, operated that gun, fired a bullet into her, causing fatal injury, all of which could have been avoided if he'd, one, bothered to check to see if the gun had live rounds in it, or, barring that, had simply not pointed the muzzle at her, as he's not supposed to do. Or, according to SAG, Screen Actors Guild guidelines, and not operated the gun while the muzzle was pointed at her. All of which is reckless creation of an unjustified risk of death to another, which is the basis for involuntary manslaughter in this case. So let me take a quick look and make sure we're streaming where we are supposed to be streaming. And it looks like we are. Pin that. Check. You never really know with Rumble. Let's take a look. Come on, Rumble. And Rumble is working as well. So we have a couple of interesting things that have happened in various motions being filed in this case, which is supposed to start in under exactly a month. So jury selection is scheduled for July 9th, and the first day of the trial proper, opening statements, should be made on July 10th, according to the current trial schedule. Now, what's been interesting the last week, while I've been gone, is a number of interesting motions, one of which is a state motion. And of course, a motion is simply a request to the court to order that something be done. And the state has submitted a motion to the court, a request to the court that the court order that Hannah Gutierrez be granted immunity, use immunity, and compelled to testify in the Alec Baldwin trial. Now, Hannah Gutierrez was, of course, the armorer on the set of Rust. She had her own involuntary manslaughter trial earlier this year because she allowed live rounds to be in the gun that was in the hands of Alec Baldwin when he shot and killed Helena Hutchins. And she was found guilty of involuntary manslaughter by the jury, unanimously, beyond any reasonable doubt. And then she was sentenced to 18 months, the maximum allowed under New Mexico law, 18 months in prison, and found to be a violent offender, meaning she's required to serve 85% of that sentence. She otherwise would have been required to serve only half of the 18 months. The judge was very unhappy with Hannah Gutierrez for a number of in-jail statements and phone calls she made that were derogatory to the judge, to the court, to everybody, really, except for Hannah Gutierrez, who still seems to believe that none of this is actually her fault and she's just being mistreated. So now that she's been convicted, it's expected, I guess, that she'll appeal her conviction. I'm not sure why. First of all, there aren't many grounds of appeal. Second, by the time she appeals, she'll have served the sentence. It's very much a Kim Potter type of situation. By the time she'd get around to having her case heard by an appellate court and a decision rendered by that appellate court, she'll have long since served the 18 months. But an appeal process is possible. And the state wants her to be compelled to testify at the Alec Baldwin trial. And so they're asking the judge to grant use immunity, meaning anything that Hannah Gutierrez would say during her compelled testimony in the Alec Baldwin trial could not be used against Hannah Gutierrez. Say, for example, she appeals and the appellate court were to reverse her conviction and she were to be tried again. The statements she makes in the Alec Baldwin trial could not be used against her in that second trial. So we're going to read through that motion that the state has submitted. Naturally, the defense is contesting this motion, and there's going to be a hearing later this month, an oral argument hearing, June 21st, where the parties will argue all this out. So we'll be sure, and I expect that to be live streamed, and we'll be covering that live stream when it happened. Another interesting thing that's happened in the last few days is the parties are obliged to notify each other of the witnesses they intend to call, so that at least in New Mexico and many other states, each party can interview the witnesses before the trial. And I think this is a great idea because ideally a trial ought not have any surprises for the parties involved. Everybody should know what witnesses will appear, what legal arguments will be made, what evidence will be presented, and what those witnesses will say on the witness stand. The purpose of the trial is not to evince evidence or find evidence or get surprising statements out of witnesses. The purpose of the trial is simply to present the evidence that everyone knows, the parties involved knows, will be presented to the jury so that the jury can play the role of finder of fact. So there ought to be no gasp moments to the parties in the course of the trial. And a great way to ensure that is to have both parties interview each other's witnesses before so they know what will be said. Now, the defense had listed a number of witnesses on their witness list to the state. And now the defense is saying, whoa, we've interviewed these people and we don't want them testifying. So we're going to withdraw them as witnesses. The state is objecting because the state knows what the real reason is for the defense not wanting these witnesses to appear in the trial, and that is because their testimony will be harmful to defendant Alec Baldwin. So the state wants these witnesses to appear. So we'll go over some of the countervailing motions that are being submitted by the parties about this issue of whether or not the defendant witnesses should be nevertheless called to testify, even though the defense doesn't want them anymore. The defense is pretending that they have only the purest of motives. They want to streamline the trial. So they're just asking the court to allow them to these witnesses. These are not the witnesses you are looking for, Judge. So that also will be argued orally on June 21st, the same live stream that will address this immunity question. So we'll cover that as well.